This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a guilty verdict of forgery with regard to insurance was affirmed and why the defendant's sentence of 8 years in prison for forgery to establish non-existent counseling that was paid for by insurance companies failed, and why the jailhouse lawyers' attempts at appeal also failed. In a case entitled The People of the State of Illinois versus Robert A. Moylan, the Court of Appeals of Illinois on March 11, 2025, dealt with the fact that Robert A. Moylan was found guilty of 7 counts of forgery for signing and delivering false documents stating that his clients had successfully completed court-ordered counseling services. Moylan was sentenced to an aggregate term of 8 years imprisonment. He appealed, claiming several errors by the court, including the denial of his motions to suppress eavesdrop recordings and evidence seized from his offices, and the denial of his request for a public defender at sentencing. Acting as his own attorney, Defendant appealed, claiming the court erred in 1, denying his motion to suppress eavesdrop recordings of counseling sessions, 2, denying his motion to suppress evidence seized from his offices, 3, allowing a client to testify about statements he made during counseling sessions, 4, denying his request for the public defender at sentencing, 5, ordering him to serve an aggregate term of 8 years in prison, and 6, entering convictions on 6 counts of forgery in violation of the One Act, One Crime rule. In August of 2017, the defendant was indicted on 7 counts of forgery. The indictments alleged that in July 2016 and February 2017, the defendant created and delivered letters which falsely stated that David Moylan and Christopher Merckx completed court-ordered counseling for driving under the influence, made false insurance claims to obtain a payment for the services, and knowingly devised a scheme to defraud Blue Cross Blue Shield of Illinois. Following the state's case in chief, defendant rested, and the jury found defendant guilty of forgery on all 7 counts and not guilty of insurance fraud or aggravated insurance fraud and wire fraud. Trial Judge Marchese concluded that the application was legally sufficient. The application, as found in the record on appeal, supported the finding. Investigator York's 18-page submission provided a detailed description of her conversation with Moylankamp's ex-girlfriend, as well as her conversations with Moylankamp, and included information regarding her conversations with the defendant. A valid search warrant must, regardless of Mr. Moylan's claims, state with particularity the place to be searched and the persons or things to be seized. Generally, when property of a specified nature is to be seized rather than particular property, then a description of its characterization and characteristics is sufficient. On the merits, the court concluded that the warrant satisfied the particularity requirement, and whether the necessary probable cause existed is governed by common sense considerations that are factual and practical, not by technical nuances. Based on York's application describing the circumstances of her investigation and the conversations she had with Pascal, Molenkamp, and Defendant, the issuing judge had a sufficient basis which to conclude that probable cause existed to search Defendant's office. Defendant also challenged the denial of his post-trial motion and his sentence based on the violation of his Sixth Amendment right to counsel of choice. Finally, he contended that his sentence was excessive, and the court noted that in determining an appropriate sentence, the circuit court must consider all relevant factors in mitigation and aggravation and balance the retributive and rehabilitative purposes of the punishment. Defendant was sentenced to 5 years imprisonment, a sentence within the statutory range for forgery, a Class 3 felony. The court found no error in the denial of the motions to suppress and concluded that the evidence obtained was legally sufficient. The Court of Appeal also found that the admission of witness testimony regarding statements Moylan made during counseling sessions was not plain error, and that Moylan's forgery convictions did not violate the one act, one crime rule, and that his 8-year aggregate sentence was not excessive or improper. And therefore the court held, 1, the circuit court did not err in denying defendant's motion to suppress eavesdrop recordings of counseling sessions. 2, the circuit court properly denied defendant's motion to suppress evidence seized from his offices. 3, admission of witnesses' testimony regarding comments defendant made during counseling session was not plain error. 4, the circuit court properly denied defendant's post-trial choice of counsel request. And 5, defendant's forgery convictions did not violate the one act, one crime rule. The judgment of the Circuit Court of DuPage County was affirmed, and the 8-year aggregate sentence was found to not be excessive or improper. In my opinion, people who commit fraudulent acts, even after they are caught, tried, and convicted, have the type of chutzpah that would exceed the gall of a man who murdered his parents and after conviction asked for mercy because he's an orphan. To bring these motions and require the Court of Appeals to write an opinion in detail on all of his weak arguments was contumacious conduct. Yet it is still important because it makes clear that in Illinois, these arguments should never be brought again, and Moylan should have been happy that he was found not guilty of the insurance fraud counts, or would have been sentenced to an even longer stay. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you will gain access to the more than 5,000 blog postings. You can also subscribe to these videos on YouTube at rumble.com. They're free. And please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.